The following audio recording has been designed for learning purposes only. Do not share, distribute, or provide any type of copies, or this audio lesson will not be made available to you. Good luck with today's lesson.
Hey, I was let go because I filed what? My whistleblower complaint, or I brought this. And not even if we take Vimman aside, like let's take that one out. We have a company. I always like to do the one, remember, with the chemicals, because this was a true case too. Employer tells you to dump the chemicals in the barrel. Don't worry, don't dispose them of the way. We got a hill, just roll it down the hill, let it fall into the lake. I think that was a New Jersey case, actually. New Jersey or New York. I really do. It was one of those states. But that's what they were doing. But you knew it was wrong to dump what? Those barrels into the lake, because eventually they started seeping into the water because, stuff started coming out of them, and then the water was getting yucky in violation of EPA. But you were let go because you refused to what? Dump, or you informed the government what they were doing, and now they let you go. You had that burden of showing, hey, I was let go because all of a sudden I made a claim saying that you were what? Dumping water when you shouldn't. We shouldn't have been dumping water because I knew what we were doing was wrong. Or maybe not even dumping it in a lake. You say, oh, you got those chemicals? Just dump them in the drains. In the floor drains? We're fine. Don't dispose of them. Just let it what? Dump it down the drain, wash some water, and let it go down. Yeah.
If the person would have actually done it, could he get in trouble in the company because he's the one who actually dumped it?
That's where, yes. If you think back to Business Law 1, you can have business crimes. Remember, we said the person who actually committed the crime could be liable, as well as what? Everybody in the business. The only thing here is, let's say he did it, but then he realized it was wrong and turned around. He might be liable. Now this is going to be with the prosecutor because maybe they need more info. What do? If he's your guy and he was dumping, he knows what's going on. He's got first-hand knowledge, right? There's a possibility the prosecutor may cut what with him? A deal. We'll grant you immunity and you give us everything we need so we can get who? The bigger ups. The ones who are really, you know what I mean? Yeah, so you can get into those type of things. And yes, he could be liable there. But again, if the prosecutor is going to use you because maybe you can provide him with everything and you're a reliable informant, they might cut him a deal and say, we'll grant you, or we won't charge you. How do I want to say this? Like maybe instead of us going for full force of maximum penalty because you were a willing witness for us and helped us, let's be lighter on the sentencing. Do you get where I'm going? Yeah. Something like that. So you can get into those type of things there. Once you do meet that burden, again, like I said, you're going to shift it over to the employer then. Once you can show that, hey, I was let go because you were, getting rid of that stuff in the drainage, that burden now shifts over to them, and they're going to have to kind of take it out of that. So we get there. The employer is going to be entitled to relief such as reinstatement, back pay, with interest, special damages. They can see these things. They can ask for all those. The employee has certain duties to employers, including the preservation of trade secrets, inventions of their employers, or things that were developed while they're employed for that person. There. The employer also has a certain right in the employment relationship, which are covered under our fair labors. Before I get into fair labors, there's one couple of things too I want to really fast mention. Dodd-Frank. Dodd-Frank Act, and it's talked about in 766, has been expanded, and it expanded on SOX. So this Dodd-Frank Act, what they've done is they've expanded the SOX statute of limitations. Remember I said you had 90 days in which to file? They've expanded it now, and they have given you a period from 90 to 180. Okay? The SOX limitations, and then the Dodd-Frank limitation is 6 years. So just kind of let you know that some changes have come in. They've also said you must exhaust all your remedies under SOX. If you're the whistleblower at OSHA and the DOL's Administrative Review Board, because they don't necessarily, they want you to go through, remember I said those agencies, we want you to exhaust your remedies, take it up through the chain before you really bring it where? Into the courts. That way we know you've exhausted every remedy you could. So if you started at that lower level, you've moved up that agency. So if, let's say it's the EPA and you're telling the whistleblower that, hey, they're depositing that stuff in the drainage, you start, if it's a one-person panel and you start with, and then let's say on review it goes to the 3, and then maybe they have a higher, did you exhaust all the remedies within that agency? And if you have, and now, you still were terminating, you still have lost in that agency, then we'll let you come on over. It just helps because we're getting you to exhaust those remedies there. So those are just a couple of things I wanted to highlight out there. Let me talk about Fair Labor Standards Act then, and this is getting to your rights of employment because I said you're covered under Fair Labor Act, also known as the Wage and Hours Act. These rights include for you wage protections, such as what is the minimal compensation? Now you can see a lot of it. We have our federal minimum law for what you can hire employees for. A lot of states are what? Changing the minimum, right? Because I'm trying to think, what is federal right now? Is it 920? Am I off? Is federal 925?
Federal's 8 something.
8 something?
Michigan went up to 9.
Yeah.
Okay, Michigan's higher 9, because I might, as I said, I might, but you have some states that, okay, if federal here is, let's say, the 8, right? You got some states that are now implementing minimum wage of being 15 an hour. Do you get where I mean? They're going for or 13 an hour, or Michigan's 9, and some are trying to go up because they're trying to help. But that's what we're talking about here. So you do have a federal level, but don't forget, some things states can also what? Take it higher. They're allowing that shared power is there, things there. But they'll tell you, here's what the minimum is. Here's what the maximum hours and overtime protections. Because if you're going to have people work more than 40 hours a week, right, that's not fair if you're only going to pay them $8 an hour and now they've worked 60 hours that week. You should be paying them if it's anything over the 40, maybe now you hit time and a half. If it's Sunday, maybe not time and a half, it's what? Double time. If it's holiday, you even get into triple time. So we're going to put these laws in effect, you know, and if we're dealing with minors, we don't want people abusing minors here. So maybe this is the maximum hours minors can work in a week while they're going to school. We'll put all this in these age restrictions. Okay, we'll prohibit that child labor law, including age and activity restrictions there. The other thing is maybe we think some things are too dangerous for minors to be doing, that maybe we'll say, okay, you're an adult, you know, because we don't want the minors maybe working on equipment stuff that could lose their what? Arm, limbs and stuff that we might say, oh, that's a little dangerous. Minors should not be dealing with this. You know, because they still might not fully understand what they're doing. And we're not trying to be mean and stuff. We're just trying to put protections in place to protect people and parties. So the other thing, these are all things we look at. FSLA, also, it's been amended. It does cover domestic service workers. When we're talking about that, we're talking about things like cooks, nannies, okay? It does not cover, though, salary employees. So if you're somebody who makes a salary of $60,000 a year, $100,000 a year, you're not going to get overtime pay because you're what? You're not kind of protected in that under the FLSA. So we get into those. Alexander Graham Bell, let me use him for a minute. He works at a supervisor. He's at a business office for the Everyone Connects telephone company. So we have Alexander, he's a supervisor, he works for Everyone Connects telephone company. While he's at work, he happens to invent a process for terminating the telephone services of delinquent subscribers. The telephone company uses this process, but they refuse to compensate him for it, claiming that they have a shop right to it. Bell then turns around, he sues them for damages on the quasi-contract theory, and at trial he admits that he developed it while he was at work during company hours, right? And he also used their company data as he did this and source material. Okay? Who do you think's going to win? The company or Bell? Why?
Because he was on work time. Just like, if you're at work and you do something like that, they basically get it, right?
Well, I'm going to let you keep answering and I'll see what others think. So you say it's the work company because he's on their time and they're going to allow to get it. Everyone agree? Anyone have different thoughts?
I would disagree, only to the point that it's his invention. It's not like anyone is influencing his decision. It's not like the company idea, it's his personal idea.
Okay.
Even though he's on their time, that's probably an issue of, hey, you might not be doing your job because you're coming up with different, you know.
And you basically say it's the company's because he's on the company time, and you're saying, no, they have a right to use it, but even though he was on his time, it's still his. Yeah. Am I correct in my thinking on how you guys are both are?
Too, so.
Yeah, that's, the idea is his, but the fact that he's maybe abusing his duty as their employee would be cause for concern.
Okay, so we've had our two arguments. How many agree with Brad? Tanisha's with you. You're not by yourself, at least. How many agree with Caleb? James was with you. Are you with him, Manny? She's got the half up there. You got a half. You got 1.5 with you. How many are unsure still? You guys can be honest. You can raise. Here, judgment's going to be for the telephone company. The employer has a shop right or an irrevocable license to use an employee's invention or ideal. If the employee in developing the invention or ideal did so on the employer's time and with the employer's machinery, all those type of things there. Okay, the business, the regulating hours, they use the data source. That's going to support the company's shop right defense there. You know, the fact that he also admitted that he did it also helps you when you get into those type of things. Any questions on that so far? I'm kind of up to labor relations law. So let's talk about labor relations law, and I'm up to the 769, so you can kind of see there. The National Labor Relations Act, NLRA, this governs the right of employees to go and unionize. So NLRB really comes into play with the unions. So think of like even baseball contracts, the basketball contracts, the football. We said they always have this union. And by the way, union law is federal law. It will never be in the state. You know, anything with the unions is always going to be governed by the federal law there because it's union law there. So the NLRA, what it does is this act, it actually applies to companies with income of $500,000 or more. It's enforced by our National Labor Relations Board, so the NLRB. And the NLRB will regulate things like the union election process, whether you want to certify, decertify the union. So I remember at the beginning of class I said how many of us are in unions. We're in unions. We pay, I'm not going to lie, union dues, because I'm sure you do too. I know I do, and sometimes they could be astronomical union dues, and sometimes they could be reasonable. Again, we're part of this union, and what's going to help us is if there's any dispute with that CBA, really we should be going to our coordinator, our grievance coordinator, saying, hey, we think they violated this. So let's say Tanisha and I both work together in the thing, and all of a sudden we're like, we're only supposed to work this many days. Per our contract, this is our thing, and this is our job duties, and this is our job responsibilities, and now they come to us and tell us they want us to do more. We could actually go to our grievance coordinator and say, hey, they're asking us to do more in our contract, and this is not what we're supposed to do under our job responsibilities. We're really doing somebody else's. This is the administration's job. We're not responsible for this. We can then file a grievance with them to say you're breaching what? That contract. And then they'll do their investigation and all those type of things there. So we will get into that type of thing. They also, I said they'll do election process, all that. They will control the rights of the employees. They'll look at that. The employees cannot be discharged for union activity. So if they do that, they could be violating, right? Getting into trouble there if they discharge us. And the employees will have we do have our limits on our union activities on the employer premises. The employers have the duty to bargain collectively with us in good faith. Now here's the other thing, when I said we can't do stuff, yes, we can do some certain union things, we can communicate. There are some issues, I know some of the laws are coming into effect where they're kind of watching some of it, because sometimes employers are really nice to collect your union dues. And sometimes now with the laws too, they want to keep it separate, where they're like, oh, we're looking for ways, because eventually the law might say that, guess what? The employer cannot collect the dues on behalf and disperse. Do you see where we're going? And there are things that they have to follow by law too, or a lot of times communications. You won't use the employer email a lot to do a lot of your union communications. You kind of take that off site and you use your personal. You know, because then that could be actually interfering there with the rights of the employer and all that. So we get into that. Let's look at the following example. One Monday, we have a labor organization. It's affiliated with the International Ladies, and I'm going to lift this because this one's a really long one. They're affiliated with the International Ladies Garment Workers Union, and they begin an organizational drive among the employees at Whittle and Sons. On the following Monday, 6 of the employees who were participating in the union drive were discharged. Immediately after the firings, the head of the company gave a speech to the remaining workers in which he made a variety of anti-union statements and threats. The union files a complaint with the NLRB alleging that the 6 employees were fired because they were engaging in what? Union organizational activity, and thus they're discharged in violation of the NLRA. The employer defends its position, arguing it had a business to run and it was barely able to survive in the global economy against cheap labor from third-party countries. It asserted the last thing it needed was union baloney. Who do you think's going to prevail there? Did the company violate the NLRA? Why?
Because they basically said they fired him because they were a part of the union. We don't want to deal with that. It makes sense, but like, can't do it.
But again, these type of, and by the way, I'm taking a lot of these are from your textbook. I may have changed some names that one. I don't think you did. A lot of these are things that really happen though, right? Employees want to organize. The employer then all of a sudden, next thing you know, people get discharged. They say, oh no, we discharged you for no reason because of yada, yada, yada. And then they come back and say, no, we weren't discharged because of this. We were really discharged because we were what? Trying to organize a union. And you violated it. And here, yes, they did violate Section 8A3 of the NLRA. It prohibits discrimination against employees because of their union activity. They violated the section when they fired the 6 workers in question. The employer expressed also anti-union animus by saying what? It's a bunch of union baloney. This coupled with the firings would threaten or coerce here for you guys, the remaining employees exercising the right then to form a union, because if they see that, they might not want to form. Yeah.
So like in that situation, 6 employees got fired for union activity. Say there were like, I don't know, 10 employees in the union that went to that drive thing. 6 of them got fired, but 4 of them stayed on. If the employer raised the defense and they were saying, oh, but these 4 are still here, you know, like you can't raise that, would they probably have a better, obviously they have a better shot if they didn't say union baloney.
They may,
But,
yeah. If
yeah.
you didn't say union baloney, definitely might help them.
Yeah.
Don't forget, so what would happen is the 6 who were fired for the union, they're gonna make the argument, no, we were really retaliated because, now I'm gonna throw some facts in there, were they the head of ups of the unions? Do you get where I'm going? Were they some of the officers of that union?
Yeah.
And the other 4 who weren't were just the what? Do you know what I mean?
Four,
Usually
yeah.
you don't have more than 6 though in the officer positions, but do you get where I'm going? Like, were they the ones who maybe were the main people behind it
Yeah.
and all that? And then don't forget, who has the burden first? Those 6. And if they can show they meet the burden that they were fired and it was because of the union activity, we're gonna shift the burden to who? The employer, and they're gonna have to show why they weren't fired on their.
Because that's where I thought the story was going. That's going to be, oh, but these ones were fired and they were fired. But,
Yeah, no, they just outright fired 6 of them. And by the way, I never said how many total employees and all that, and I don't know off the top. The other thing you guys could ask is, do they have the right to free speech? Let's talk about the employer for a minute. He said it's union baloney. Does he have the right to free speech? When he said the last thing we need is union baloney. Do you see how now you start getting into other areas like, would they claim, well, I have this right to say it. Do you think that violates NLRA, or do you think he's going to be okay there?
I think you'd be okay.
You say he's okay?
Isn't there something you could go to jail for, like if you talk about somebody to another person? It's like
Well, it's not.
something of character.
It's not jail. You're thinking tort defamation right now. Because defamation is a tort action, and more we're going to see damages if you make a false statement about somebody with the intent to harm their reputation to that third person, and in fact they're harmed as a result.
Would that kind of count as it because they're calling what they're like doing baloney? And
But
then
is that more you're intentionally looking to defame someone, or is it more your opinion? Do you see where we're going?
Yeah.
Because defamation, if it's an opinion, we're not going to be liable. And we've always done this since Tanisha, I know, had me for BLAW 1, and James had me for BLAW 1. I'm going to use you two on this one so nobody feels like. If James came up to me and said, what do you think of Tanisha? And I basically, she knows I don't really mean this, but for class purposes, I call James and I go, I think she's the biggest bitch in the world. Was I intentionally defaming her, or is that more my opinion?
It's more of your opinion.
even though I made that statement to him, and even though that statement could be false because she might not be the biggest bitch in the whole world, she might be what? The absolute biggest sweetheart in the whole world. Who would do anything for you. Do you know what I mean?
Yeah, but he asked you for
What I thought. And that's more my opinion. So here, if she turned around and sued me, she's going to lose. Because I'm going to argue, no, that's more my opinion, and I wasn't making it with the intent to what? Harm her reputation.
Yeah, like
and on
if you
top
just
of it.
walked up to a person and it's like, yeah, she's a bitch. then-
And those are hard cases to win by way of defamation. And the other thing is, she also has to prove that she was harmed as a result of that. So let's say James still hired her, based on what I said, she wasn't even harmed. So it really gets into those type of things. Thanks for being a good sport. She always picks on me on that. I just figured since you guys had me, you wouldn't mind because you knew where I was going from that. There. When we get to the free speech, just so you know, under NLRB Section 8C of the Act, it does allow employer free speech so long as the language contains no threat of reprisal or promise of benefits concerning support for the union. In this case, the firings coupled with that union baloney language made his speech a violation of the Act. Because it was coupled with the firing. Do you know what I mean? Had he not fired anybody and just said what? It's a bunch of union baloney or something like that, he may have been okay. And he may have won on the free speech there because it didn't really pose a threat or anything. So we get into that. Let me do another example here. I have Bob. Bob the Builder. Bob the Builder happens to submit an application to the maintenance department of Handy Manny Company. And Bob had 9 years experience at a neighboring company at the time of his application to Handy Manny. Now, Bob is vice president of the local industrial workers union. In his preliminary interview with the company, Mrs. Wendy Little asked Bob if he was involved in any union activity. So he works for another place, has union activity, goes to this interview. She asks him, do you have any, are you involved in union activity? And he details his involvement to her. So he tells her about it. She informs Bob that Handy Manny happens to be a non-union shop. But she does take notes of this stuff. Do you get where I'm going? Write down what he answers. And he asked how he felt about this. That, hey, we're a non-union. How do you feel about this? And like I said, she takes notes of all this stuff. She takes these notes from her interview, and she goes and she writes, it seems as he would lean to third-party intervention. Meaning he's kind of going to favor what? The union, even though our place is a non-union. Bob's, after he gives that response, she writes that company officials testify that Bob was qualified because here's what happened. He ends up not getting the job. He claims he didn't get it because he was what? Based on what he said, and he's for union. They claim, no, you just didn't get it. But they do testify at trial that he was qualified for the job, and he's exactly what they were looking for. He just wasn't hired. Bob claims he was discriminated against, and Handy Mandy denies any of that discrimination. Who do you think would win here? Why?
Because I bet if they didn't know any of that union information, then probably would have got the job because they said he was qualified for it. And that's exactly what they wanted, but he didn't get the job. So I think that's kind of iffy. I think it's because.
Okay. Does everyone agree? Does the fact that he wasn't already working for them make any difference to you guys? To say whether or not they're protected from anti-union union activity. Do you see where I'm going? This is what we're looking at because this is a prospective employee versus what? An actual employee, right? So I guess I can word it this way, and I'm not saying you're right or wrong right now. I'm just wanting you guys to think, to realize, is a job applicant as opposed to an employee entitled to protection from anti-union discrimination? That's what.
Yes.
No.
You're saying is a non-employee protected by?
Yeah, you're a job applicant.
Yes.
Are you protected?
Yeah.
And you kind of were answering that way too, looking at it, right?
You can't discriminate in interviews or applications.
And that is true. You are protected. Job applicants as well as employees, you are protected from anti-union discrimination. So, and this is the whole thing here. It'll kind of go back to, I'm going to pull this out for a minute, kind of from Chapter 1 of blaw 1, and we'll talk about it a little bit more here. But even when employers search your social media posts, you know, or they ask about your social media posts, and then they don't hire you. And sometimes that question becomes, well, you didn't get the job because maybe it was based on what they found of you on the social media post. You know, is it harder to prove that when you're a prospective employee versus an employee, you don't get that position? It is a little bit harder. And the same here, even though you're not an employee yet, if you're in the union, you're still protected for that anti-union, because if you can show that they didn't hire you, and what was the key? You said he was what? And our facts, what was the key? You said he was protected because they said he was what?
He was qualified for the job and
Yeah.
exactly what they needed.
And that's what kind of killed him in this situation, because they testified and said he was what? Qualified. So what was the real reason you didn't hire him then? Because if he was exactly what you wanted and he was qualified, but the fact that he made those statements, you kind of didn't pick him because of those statements. You know, so here he would have won. Because the officials were aware of his union activities, suspicion of discrimination would be justified here. Because now had they said, oh, he just didn't meet our disqualifications, we had the guy we hired actually had more qualifications, then they may have been what? Okay. But not when you say, yeah, he's exactly what we wanted. There. Then I was kind of flipping because there was another one I wanted to look at. Let's look at number 8 on page 792. And I'm going to give you guys a few minutes to read it. And if someone needs my book, I can pass my book along. Yeah.
With the last one, so
Yeah.
when they asked him, like, are you involved in any union activity, if he were to have lied and then said no, and then and then he gets hired, and then they find out, they fire him without being, because they would be firing him based on his involvement in the union. He lied in the interview when he said he wasn't involved.
And I'm not going to lie to you, that if you came into my office, I'd probably say, let me go do research on cases and see how many were job applicants that actually lied on their interview and then were later discharged because they found out later of the union. Because really, you're supposed to be what? Truthful in your application. Do you know what I mean? So off the top, I don't know if there's cases out there that have dealt with that issue. So I'm going to tell you right now, it kind of probably depends. But the fact that you could prove that they still did it maybe because of the union,
Yeah, that's what
you
I
would
would
still
assume.
probably be
Because you can't
protected.
necessarily say they,
Right.
because what are you going to say? Oh, well, we wouldn't have hired you if you were a part of the union.
Right.
So, yeah.
And by him saying, well, I figured if I said I was part of the union, it would have given me an option not to get hired because I was afraid they would discriminate on me. The fact that, do you get where I'm going?
Yeah.
I just, off the top, I don't know how many cases off the top of the head without really doing research are out there on not disclosing it.
Yeah.
And then, or when I say not disclosing, let me rephrase that. It's not that you didn't disclose it, you purposely what? Lied on that. Now, if you didn't disclose it and they never asked, and then you were fired, and then they found out that you were in union, I again would go with the, again though, if they've hired you and you're an employee, it's gonna make it much easier because you're what? An employee to say, you fired me because of my what? Union activity. Yeah. Do you get where I'm going? And this is where being an employee and sometimes the perspective, depending on what we're suing for, this person, employee, might have a little bit easier time sometimes showing something than maybe the perspective. Again, we're talking about union activity there.
Yeah.
So they do have that more protection. But like if it was someone out there on social media and they don't hire you, and it might be, well, we saw them holding a beer in their hand, or wine, and every picture we looked at in social media, they were drunk. We just didn't think they'd be a good fit. As long as there's no discrimination, it's going to be a lot harder to show I wasn't hired.
Yeah.
Do you know what I mean?
Where would someone have cause to believe that they were discriminated against based on like their social media posts?
I used to give this in my online. I used to have them watch a video, and they were doing an interview. Okay, and the person was, you had the managers all talking about 6 candidates, and I asked the students to rank them. And they would talk about each candidate. One, they found nothing on the social media, but they thought in the interview they were kind of blah, to get where we're going. The other one, they had a person that was an ideal person, but when they went to social media, they saw a tattoo on the person's like arm or something. The tattoo actually represented a group that was not a good group.
Okay.
Do you see where we're going?
Yeah.
And the question was, you know, and I always would pose this question to my students. I said, do you have to be careful though? Because what if the person who got that tattoo really did not know what the tattoo meant and got it because they just happened to be somewhere, saw it and thought, this is a cool looking tattoo.
Was that spring break tattoo?
Do you get where I'm going?
Yeah.
And I'm like, you know, should that be reason then for them not? Because they're going on social media and they would have never seen that on social media because it was a picture without them saying a shirt on their back or whatever, where it could have been what? Covered in the interview, they would have never known.
Yeah.
And that's where we're talking there, like, did you not get it because of the tattoo and what it represented? Or, and again, if you're a prospective, that's gonna be harder maybe to prove than if you were an employee already. Because if you were an employee and then they found out you had it and then they discharged you and you had awesome reviews, you've never been disciplined,
Yeah.
do you see how it makes it like,
Never
why are you
was.
really, yeah.
So it just depends on whether you're a perspective or an actual one.
When you get into things like that, and that's why I said this one's a little bit different because it's specifically dealing with the union, and we're
Yeah.
going to say union does protect you for do you know what I mean? They can't discriminate you by anti-union if they know, hey, we're a non-union shop, but you're someone in the union. Because the biggest fear there would be that you're going to come in and try and get what in our company? A union.
I'm sorry, but can't some job actually fire you for stuff like that? Like if you work for the government, like if the president posted a thing on Instagram.
Well, president right now can't be fired because he just, how do I say it? I mean, right now, according to him, he's above the law. But, and by the way, they won't fire him, he'd be impeached. Do you get where I'm going?
Yeah, but I'm like,
Yeah.
if you're like a high lawyer.
But a lot of those people can be, and yes, your
because
company,
It doesn't look good for the company.
go back to this. Go back, if you're hired and they have certain things. Now companies do though, because a lot of companies will say social media, they cannot ask for your PIN number. Now, they can discover things, let's say.
Like on your credit
You're-
report, they can run your credit report though.
Well, credit, but they can't ask you, if you came in an interview with me, I can't ask you to say, give me your PIN number
No.
for your social. I can go look around. Now, do a lot of employers do background searches now and use social media?
Yes.
Oh, yeah, they do. You know, and that's why everybody says clean up your social media, look at what you're posting online, what can come back and haunt you. Because if you're going to put it out there in the World Wide Web and it's public,
Yeah.
and we see you slung over, drunk, throwing up on cars. Okay, I'm going to tell this story because I did go to a class reunion once. And I remember sitting at a class reunion, one of the girls, I'm not going to do any names or anything, right? But was sitting in the chair and just a little hammer.
At our
Yeah.
class reunion?
Oh, yeah, at our class reunion. And I remember a bunch of people go, oh, look at her. And I swear at one point, I really do think she was throwing up on herself while sitting in the chair. I mean, I didn't really stick around to really watch this. Do you get where I'm going? Like, but I saw it. But I remember one of my other friends, what did they have?
Their phone.
Their little phone taking pictures of her sitting there. And all I thought was, that's terrible. What are you going to do? Post this on? But do you get where I'm going? Now, if that gets posted out there, and let's say the employer happens to see this, and let's make it even worse. Let's just assume she happens to be wearing a shirt that has the company logo. They might let you go because to them, that's not reflecting good on what? The company. Sponsors. Michael Phelps
Yeah.
with the bomb. How many sponsors did he lose because of that? Do you get where I'm going? Because that doesn't reflect good on the company.
Yeah.
And you're doing something there. And that's where people say, watch what you put on social media. You know, and I feel bad because I've heard other stories about the person that was at class reunion too, a couple other incidents, and I'm just like, whoo, you'd never learn, you know, making out with someone on the back of a car at a golf outing. You know, and you're just like, but if people are taking pictures of that, and now that gets out there, and then employers see that, they might look and go, ooh, does this really represent, especially depending on your position.
Yeah.
You know, they might look at it and say, this violates our moral clauses. That's the other thing, going back to contracts. Do you got moral clauses in here? And what's deemed moral or not, and is that a condition subsequent to terminate you from your employment?
Position,
Don't they have laws for that anyways? Like
For-
with people taking photos of you and posting without permission?
Well, that's getting into invasion of privacy possibly. But do you see where we're going?
Yeah. Only ask because I know like with certain companies, you know, they'll ask you to sign a form if it's
Well, they'll
okay
do
for you
this,
to
but
post
this
your
is someone
pictures.
even out in the public. If you're out in the public doing something though, How many times do paparazzi, why do you think celebrities, right, in the public and then the pictures?
And it
But
gets-
they're out in the public domain. They put themselves out there. The
And it
celebs-
gets reposted so many times, like you never know who truly took the photo and posted it first.
Mhm.
I mean, they can find out.
The original
You know,
source.
your
It is.
Facebook knows that.
And I just tell you guys, watch what you post out there. Now, I don't Facebook. I'll be honest. I don't even have a Facebook account.
Really?
I don't. None of my kids do either. It's so funny. None of them ask. Now they do Snap and stuff, and I always joke around and tell them I'm going to join Snap, and will they Snap? Join me. Okay, here's the funny thing. I'll tell this story, and I know it's not employment related, but getting back to what you post. My daughter last night, I come home and my one son goes to her, "I saw what you posted on TikTok." And I go, "What are you posting on TikTok? Like, is it inappropriate and all this?" Because she's only 14. And my son was laughing. He goes, and somehow the reason he saw it is because my other son somehow got it and found it and was showing him. But it was when she was younger and they were singing songs like in the room. And the sad thing is she had it under her name. And I go, first off, you don't put anything under your name out there. Because I'm like, I yell at them all the time. And again, that might be the attorney in me. When you guys all look at me and say, really, you don't have Facebook? I just don't post a lot out there. Same with LinkedIn. You go to my LinkedIn account, I'm not going to lie. You guys go look at my LinkedIn account. If you Google my name, it is very vanilla. I don't even know what you guys see. It's probably set to public. But all you will see is that I work at Macomb. I will not include my resume. My thought is if I'm going to apply for my job, you can have my resume then. Why should everybody else know what I've done in my life? Why? So you can just take my info maybe and beef it up as yours? Because I've seen people have done that, by the way. They make fake LinkedIn account and use other people's info and then change the names and a few things. And my thought is everybody doesn't need to know my history of what I've done. If I want to interview for you, I'll give you my whole resume then. So I keep it very generic. But again, that just might be me, field, or I just don't like that thought of everybody has to know. Yeah. And again, it might not be that I have stuff to do, but hide. So let's look at number 8 for a minute. I'll give you guys 5 minutes to a few minutes to go through it. You can talk to your neighbors and we'll discuss it. What do you think the outcome should be?
I have a question.
Yeah.
So she is a sole train operator at Guildford and she holds a part-time.
Oh, I have to reread it, so I haven't done this one in
I
a
was
while.
gonna ask you, is that the same job or is the shop steward a different job?
She was employed as a sole crane operator and she held a part-time union position. So
It's the same place?
she works at the same place, but she's their union and she has this job.
Got you.
Yeah. I'm just gonna send this now so I don't forget. Bless you.
Thank you.
guys thinking?
Yes and no.
Hmm?
Yes and no.
You say yes and no. Yes to what, no to what?
So, I say yes that the layoff did violate, what she was saying that it violated as far as that, but more no, just because like you can't just tell your company you're gonna start a strike and expect nothing to happen. But they just they made it so that they wouldn't look like they were doing something wrong, so they pretty much just was like, okay, she's gonna start a strike if we don't do this, so let's go ahead and buy these parts so that she no longer has a job, and we'll say that, you know, since we bought these parts, we no longer need your services, so that if she did, you know.
So who would you fine for? Because you're yes and no, so who would you fine for as the final result?
Probably more for the company than her.
Okay.
If she had never said that she was, you know, gonna go on strike, because a strike doesn't look good for any company.
Okay.
If she would have said something completely different, like, hey, we need a new contract by this time, and these things aren't working, and these are violating, you know, these, what was it, the health, safety and health, then, you know, they would have did something different. But because she came to them, you know, like, hey, I'm going on strike, you know, if y'all don't do this, they're like, okay, we need to get rid of her because we can't afford a strike. So.
Does everybody agree with that?
You know,
Does everybody favor more the company than her?
I do.
Why?
I don't know. I was kind of confused, but at the same time, if they don't need her anymore because they just bought new equipment, then that's all they need to say if she tries to sue. It's like, we bought new equipment, she doesn't have a job anymore. So, but at the same time, it said that the company was not planning on using the crane in the future.
Go, James. What do you think?
I think the company's got the upper hand here. I don't think it has anything to do with the OSHA whistleblowing or the strike talks. It all comes down to the fact that her job is now obsolete, and that's just how industry goes. And she's not, the other important thing is that she has not been terminated. She's just been laid off. So I
So
don't.
three of you so far are all company. Everyone else agree? Agree?
I think
Agree?
it's hilarious.
Why do you think it's hilarious?
Just because it's like, she was like working, and she was fine, she was like, haha, I'm gonna get you guys, this is wrong. And
Well,
this is OSHA, and then they're like, alright, see ya, but like they got around it to where it's kinda like, yeah, you know, your job's just not there, sorry. Like they kinda pulled the rug out from under her, and it's really funny to me. I don't know.
it's not.
In my opinion, like, I would agree with the fact that, like, there's no work for her to do because her job's obsolete. But at the same time, if you're not following OSHA standards, like, wouldn't, I mean, this particular case doesn't have much to do with the whistleblowing itself. But if I were her, I'd try to find something else that I could sue them for, and maybe not necessarily like the wrongful termination because of lack of work, but you know, something else in regards to the whistleblowing, because I don't think that there's much that she could do because her job's obsolete. But at the same time, I think
Was her job obsolete?
it would have never been had she not said she was gonna cause a strike.
So
They weren't thinking about buying
Yeah,
new
really.
forklifts. They would have never bought forklifts if she would have came at them in a different way. And like, hey, this is violating the health and safety. We need to get this figured out by June 15th. And they would be like, okay, we'll get a new contract going. She's talking about, we're going on strike. They're like, okay, we need to get rid of her now. They could have bought forklifts a long time ago.
So we have three issues we're kind of looking at, because we have our contract for employment, we have the OSHA, and then we're going on strike, which is the union, right, type thing there. What did they do though? She says on May 22nd, an OSHA inspector arrived at the plant and she told her supervisor, I blew the whistle. On the 23rd, they rented and later purchased 2 large electric forklifts that were used to do the work that was previously performed by what? The crane. And what was she? The crane operator. So you got 2 forklifts that was done by 1 crane. Forklift's not going to what? Do it on its own. Does somebody have to do that? So you had 1 person was doing it with a crane, you got rid of to get what? A 2-person job, right?
Did they say that since they bought the forklifts or whatever, that it made them go broke?
Well, they laid her off within her classification as crane operator. It says the contract provided for arbitration. It prohibited discipline on discharge without just cause. So you get into those things. The evidence indicates that the layoff, when they laid her off for lack of work, was actually a pretext. Because here, there was no reduction of work, simply the substitution of what? We didn't reduce the work. We just got rid of your crane, which was 1-person job, and got a 2-person job. So did you really reduce your amount of work then? No, if anything, it looks like because you're getting 2 that you probably have what? More work. So they're going to lose on that theory, aren't they? Because did they really lay her off because there was a reduction in work? Mm-mm. So you get into that, and the facts didn't indicate there was any economic justification for that. Okay? That was, so to the contrary, you would now need 2 employees to do the work that was really done by what? 1 employee, which was her. Yeah.
But usually in a warehouse or a factory setting, nobody is hired just to be a forklift operator. It's just an extra skill that the general employees learn, and some of them are certified to operate a forklift, and some of them are not. But you're not hiring 2 people just to operate those forklifts. At worst, you're bringing.
But to let her go and say we're reducing, couldn't she maybe have still operated one of the forklifts or something, or get her trained?
No, she might not have had the training for a forklift.
Well,
Operating a crane is a completely separate set of skills.
I know, because one moves around and
So instead of
forklift
training
drives.
her to do a forklift, they had somebody else that knew how to do a forklift to take over that job.
But then
So
we
they
get
rid
into,
of her.
when did they purchase these forklifts?
After she went on strike.
But wasn't the crane
I said she was
like
gonna go on
against
strike.
OSHA? Isn't that what?
Well, that's her, they're going to lose on a couple counts.
Was that
So,
the crane was against OSHA? And
no, it was what they had violations.
Yeah, what's the business?
There were 7 existing violations of occupational health that were brought to her attention by members of the bargaining union.
And it
So
was-
her union, because don't forget, she was what? The rep. They come to her and say, hey, people are violating OSHA. So as a rep, she then informs and says, hey, there's violations of OSHA. So not only did they reduce her work, then they said, do you get where we're going? So here's what happens. They lose on all 3. They violated the National Labor Relations Act to discriminate against her union activity, they said, because the employer's union activity. They said she advised the company the union would strike if the new contract wasn't reached, as was her right. Because Richards was informed of the alleged OSHA violations through her union position, that gave them a second reason for the NLR board to require that Richards be reinstated, because she was only doing it because what? She was the union rep, so she's the one who came and disclosed it, because all her union members came to who? Her. And then the occupational health safety also served as an independent protection for her, because once she told them of what was going on, you basically, looks like you let her go in retaliation for what? Whistleblowing. You know, and you're trying to say the pretext is, oh, well, we don't need your job anymore. It's reduction in force because we got this. And then the third one was by her contract. So they actually kind of got nailed in all 3 spots.
Yeah, I thought that it was like a job that was supposed to be done by a forklift, and they were like, the crane can do it. Because like I've been in those jobs where they're like, we should probably use this, and they're like, we can just do it this way.
And the other thing is, their union contract said if we have any disputes, we're supposed to go to where? Arbitration. And you didn't even go where? To arbitrate our dispute. You basically, what? We're going to lay you off as a reduction in force.
Because, I thought that, and so I was like, oh, yeah, the crane's against OSHA, and the OSHA comes, and you're like,
Yeah.
oh, we gotta, okay, we'll change it, Okay, and then we get rid of the crane, we get the proper materials, and so her job, that's what I was thinking. But no.
Yeah, but you see how sometimes you can have different acts coming into play? So even if she would have lost, say, on the union part, she still had OSHA that would protect her because then she went and disclosed this. But again, she was a union member, so NLRA still came into play, and but you did get into that, and the fact that you didn't arbitrate, and our contract says we have to arbitrate for any disputes in the contract, and you didn't even do that. You just basically let me go on all this stuff. Let's talk about then for a minute here strikes. Employers do have the right to strike in the event that no labor agreement can be reached. So if we're working on our agreement and say we can't come to agreement on the terms, we can do an economic strike, because if there's an impasse, we can go and do this economic strike. Here's the rule though. If it's an economic strike, those are legal, right? We can do this. The employer can hire temporary replacement workers for us. We will not get our job back then until our position opens what? Back up. So even though they're allowed to hire us back, we don't automatically get our job back once the strike ends, because let's say we come to agreement, if it's an economic strike, we have to wait till the position opens up again, and then you can reapply. Do you see where we're going? So if they hire temporary workers to fill us while we're on economic strikes, it doesn't mean we automatically get our job back. If, however, the strike is in protest to the employer's unfair labor practice, because they've violated something under labor law there and they've done an unfair labor practice, then these strikers do have a right to get their employment back upon that getting resolved. Do you see where we're going? You don't have to wait till it reopens. You get your job back right away, which means if they hired someone temporary for your position in the unfair labor strike, I get it what? Coming back there. Let's talk about strikes for a minute here. There are actually different types of strikes. We can have primary picketing, secondary picketing, and mass picketing. So those are the three types here that we'll talk about. If you have primary picketing, this is going to be legal. This is where persons are placed outside the business site where the labor is dispute exists as to the persons, so they can inform the public. Right now, don't ask me why, but I always think of Charlie Brown and all them. And Snoopy, but I just picture Snoopy and all that with a little thing going around like, we will not work, walking around in their little sticks. That's okay. It's primary. It's in front of the location. You cannot do things, though, like put tacks and all that on the ground, so when people drive through the picket line, they get what? Flat tires, or you can't take a brick now and throw it through their window as they're coming through. That is kind of, yes, you had that right to legal, but if you do that and people are injured, you could not get your job back, even though you might have the right at the end, because you've done stuff that was not proper there. Secondary picketing, this is where the person pickets an employer in which the union doesn't have a dispute, but what you're doing is you're trying to dissuade that employer from doing business with who? The party you actually have the dispute with. So think of auto companies for a minute. You're not picketing in front of GM and all them. You might be picketing in front of who? Their suppliers. Do you see where we're going? Because you have a dispute with GM, but you're going in front of the supplier, so that will maybe persuade them on doing what? Business with GM. Okay? Mass picketing, that's an illegal tactic where the picketers mass together in great numbers in front of the gates to the businesses, and we basically shut you down. We're not going to try and let you get through. What? We're going to mass picket so you can't even get through, and we'll completely shut you down. That is illegal. Okay? When we get to that. And by the way, secondary picketing is also generally illegal too, but there's times it's there. We do have regulations by the union that's talked about in 776, like what they'll regulate, the internal union affairs, all that. Let me get into pensions. So here we get into employee pensions. All employee pensions are subject to the protection provisions of ERISA, which is your Employment Retirement Income Security Act. And what happens is ERISA requires vesting within certain time periods, because historically people used to stay at companies and they wouldn't get vested until they had been there for 20, 18, 20, 25 years. Well, guess what? People don't stay at their jobs anymore for what? 18, 20, 30 years, 40. It's very seldom that you might see that sometimes. But then again, depending on your position, you might be there a long time. So, but what ERISA now does is says you must be vested within 5 to 7 years. Your company's got picked. They're either going to vest you by 5 years, they're going to vest you by 7 years. So under this income security thing there. What ERISA does is it requires vesting within the certain time requirements, It also does, you have to have adequate funding of your pension plans, and you'll have annual reporting to employees there. Also, by the way, if you're under a plan, you will still sometimes when you leave a company, still by law, they have to still notify anybody who's in the plan, whether you're an employer or not. And they have certain guidelines they have to file, or else they could be liable for each time they don't notify these people. That's why you're always getting those plan books, from the ERISA. I have a company I haven't worked for, Reed Elsevier, probably for at least a good 15 years, I'd say. And I still get all my stuff because I still have stocks with them, right? So all that stuff, I got vested with them. I only had to be working for them for a year. I was fully vested. I'm entitled to that, you know what I mean? My stocks and all that, they'll send me my information. So what happens here is when you are doing ERISA, there are two types of plans you can see that they will fund for you when we're dealing with pensions. A defined contribution plan and a defined benefit plan. Most of your companies today are following defined contribution plans. Why? Because it's more like your 401s. And the employee is doing it. They are not responsible then, because if all of a sudden the company goes bankrupt and closed up, they're not responsible for the fund anymore because they're not the overseers of the fund. Defined benefit, they actually have to get insurance that will cover that. So if they go bankrupt or they're underfunded in the account, they still have to pay, which is why several years back, a lot of companies start getting rid of the defined benefits and have gone to the defined contributions. There are some, I don't know if you guys ever knew, the MIPSers and all that. That's a Michigan Public Retirement Fund. Judges are in there, teachers are in there, and stuff like that in the union. But there was that big thing when, was it Granholm, changed the law on the medical benefits because those were defined benefit plans, and they started withholding money in violation. Do you see where I'm going? That's why there was a big lawsuit in Michigan with all that, because we said, wait, you're violating the funds. You shouldn't be taking out money for the vet, you know what I mean? Because you're underfunded or something like that. You can't change this. It's a defined benefit type thing. I mean, they changed later some of the stuff, but they had to pay money back under there because it was a defined benefit plan. Let me talk about other things. So that's the main thing there with ERISA, the funding, the vesting. We have other things such as unemployment compensation. We'll talk about Family Medical Leave Act, Social Security benefits. These all provide source of income security when events beyond the employer's control occur. So you get injured or you have to go off for medical leave, things like that. Employees are afforded some job protection security in the form of unemployment compensation, retirement benefits under Social Security, and medical leaves with protection for job and provisions. Unemployment. Let me talk about that one for a minute here. If you are unemployed, so you are laid off and stuff, you will see whether or not you are eligible for there. And a lot of times employers are paying to fund you, so when you are laid off from your job, you can go seek what?
Good luck with today's lesson.